Thank you. You may be seated. Her Majesty the Queen versus Owen Edward Smith. W. Paul Riley, QC, and Kevin Wilson for the appellant. Kirk I. Tusa and John Conroy, QC, Matthew J. Jackson, and Bibas D. Vase for the respondent. Gerald Chan and Nader R. Hassan for the Intervenor Criminal Lawyers Association. Andrew K. Loken and Deborah McKenna for the Intervenor Canadian Civil Liberties Association. Jason B. Gradle for the Intervenor British Columbia Civil Liberties Association. Julius H. Gray and Genevieve Gray for the Intervenors Santé Cannabis written submissions only, and no one appearing for the Intervenors Canadian AIDS Society et al. Mr. Riley.
Chief Justice, Justices, the Charter of Rights does not include a freestanding constitutional right to medical marijuana, much less a freestanding right to produce and distribute derivative marijuana products. The question in this case was whether a particular legislative scheme that provided for medical access to marijuana but did not allow for access to derivative marijuana products was shown to infringe the right to life, liberty, and security of the person in Section 7 of the Charter. The specific question for this Court is whether the courts below applied the correct legal or constitutional standards when trying to resolve that issue. So, in bringing this appeal, the Crown is not asking this Court to reweigh the evidence. We're not inviting the Court to pronounce on any evidentiary issues with respect to botany. So, for example, the Crown is not asking the Court to interpret the evidence concerning the significance of glandular trichromes on a marijuana plant. The Crown is asking the Court to apply, and if necessary, clarify, the legal standards or thresholds under Section 7 of the Charter. And the Crown argument will address legal standards or thresholds under both phases of the Section 7 Charter analysis. And to be clear, this is just an overview of the arguments the Crown will present, and I'll obviously get into them in more detail. At the first stage, the Crown is asking the Court to pronounce on the legal threshold that an applicant must meet to establish that liberty and security of the person interests are engaged. In the context of access to controlled substances, is it enough for an applicant to merely assert or believe that he or she is making a medical decision? Or must the claim meet some objective standard or threshold? That's at the first stage. At the second stage, if it is reached, the Crown is asking the Court to address and apply the burden of proof required for an applicant to demonstrate that a deprivation of liberty or security of the person is inconsistent with the principles of fundamental justice. And we say that burden is on the applicant. The Crown will also address...
I just want to be clear, it's just that this Court has come out with a very thorough examination of those legal principles in Carter. Are you asking us to refine, explain, change Carter in some way?
On the first stage, I would say this, that with regard to the threshold that has to be met, I say, fair enough, apply the principles in Carter, but it's a particular context here, and the context is access to controlled substances for a medical purpose. And it may require some refinement of how that threshold works in that particular context. We say that if the courts below had, in effect, applied the threshold that has been applied in the leading case in this area, Parker, then there is no basis on which the claims could have succeeded at the first stage of the analysis. At the second stage of the analysis, there was a clear error on the part of the courts below in effectively reversing the burden under the principles of fundamental justice to show not that the applicant had to show that the deprivation of liberty was inconsistent with the principles of fundamental justice, but actually requiring the Crown to prove the opposite. The Crown had to prove that the law was not arbitrary. And that's a key point, especially in the context of a regulatory scheme that operates on the basis of the reverse proposition. And I'll explain what I mean by that as we go. I should say also by way of introduction, the Crown will also address as a preliminary point the question of who should have standing to advance a Section 7 charter claim. And here, the question is there a point at which someone who operates entirely outside of a particular scheme has the ability to raise and allege deficiencies in that scheme as a defense to a criminal charge under a related act? That's the question. So it's not asking the court to overturn or revisit the leading cases of Big M, Drug Mart, and Morgentaler, but rather ask, is there a refinement or a point at which that reasoning falls down or doesn't apply? So I will say this as well, that this case is not about dried marijuana versus other forms of marijuana. It's about whether a scheme that allows for access to marijuana for medical purposes must, as a matter of constitutional law, be extended to all other substances listed in Schedule 2 of the CDSA. So we're talking about marijuana derivatives. These are separate substances that are derived from the marijuana plant. So THC, cannabis resin, and other derivatives that are called cannabinoids. The CDSA regulates these derivatives in much the same way that it regulates opium, heroin, and other opiates that are all derived from opium poppies, but they're all discrete substances, and they have different potencies, different concentrations, different risk profiles. And so the question is not, well, dried marijuana versus some other kind of marijuana. These are discrete substances that are scheduled in the CDSA, and the trial judge's ruling said, well, you must apply the medical access regime to all of them. And that's what the case is about. Now, with regard to the facts of the case, every constitutional issue arises in a particular set of facts, and context is obviously very important. But the facts in this case are fully set out in the Crown's factum, and I'm just going to say enough to set the table for the arguments. So I will say this. Firstly, with regard to the respondent, this is Owen Edward Smith. He was charged with the offense of possession of THC for the purpose of trafficking. He was found in possession of a large quantity of and was engaged in producing derivative marijuana products, cookies, oil, etc., all containing THC. The evidence at the charter application was that his intent was to provide these substances to an unincorporated enterprise, the Cannabis Buyers Club of Canada, the CBCC, engaged in the distribution of marijuana and derivative marijuana products to people who were believed by the principal of that enterprise, the principal of the CBCC, to require marijuana for medical purposes. Now that brings me then to the CBCC witnesses. There were 4 witnesses who were customers or members of the CBCC who testified. All 4 used both. They used both dried marijuana and derivative cannabis products. And they believed that the derivative products were either beneficial to their health or helped them to treat some of their health problems. However, based on their testimony, it would be impossible to discern, 1, what is the actual basis for that belief, or 2, whether marijuana alone or any other legally available product could have been used to reasonably treat each of the conditions that they suffered from. So there was no real link between the conditions that they were suffering from and the use of derivative marijuana products as the only realistic way to treat those conditions. There was no evidence about that. To summarize the evidence of the CBCC witnesses, I say this. The witnesses each expressed a subjective preference to use derivative marijuana products to treat some of their ailments some of the time.
The expert witnesses.
Yes, and that brings me to the expert evidence. The expert evidence, this much we can say is clear. Marijuana has some medicinal properties, but the precise basis for its efficacy is not clearly established through a body of scientific research. And what I mean by that is there haven't been a great number of double-blind studies the way other drugs have been studied and regulated. By contrast, the evidence was clear. There are 3 pharmaceutical drugs containing cannabis or one of its extracts, its active ingredients, which have gone through the regulatory approval process, been tested and approved for sale in Canada. Moving on, if we look at cannabis, marijuana, the evidence was that there were 5 ways of ingesting it, and I'll explain why this is relevant in a minute. Smoking, vaporization, oral ingestion, transmucosal spray, and topical administration. Now, if we look at the cannabis products that are actually available, legally available for use in Canada, dried marijuana, Marinol, Sesamet, and Sativex. These legally available products provide for every form of ingestion except topical use, topical administration. And on topical administration, the trial judge reached no conclusion. He said that method of administration was controversial, and he reached no conclusion. So there are legally available products that allow for every method of ingestion that on the evidence was accepted to be in some way effective.
I thought the evidence was that the least safe method was smoking.
The least safe?
Method of ingesting marijuana was the one that is legally available under the scheme.
Right. I think when you talk about safety, I mean, you really are involved in a guessing game because there's not a lot of scientific research in terms of double-blind studies of the substances. But I will say this.
About smoking?
Well, no question that smoking. But in every case, when someone engages in using marijuana, it's sort of a cost-benefit analysis between the detriments of smoking versus the medicinal properties that one gets from marijuana use. So it alleviates certain conditions or symptoms, but it has detriments. But I'll just say this as well, that even dried marijuana, you don't have to smoke it. You can use a vaporizer if you choose to do so, and that doesn't involve the same kind of inhalation issues as smoking does. And indeed, the CBCC, the entity that was in issue in this case, provided to the members of its club, it had available vaporizers. I will say this, though, that if someone says, I need marijuana, but I don't want to smoke it, they have a host of legally available options. They can obtain an authorization to possess marijuana and they can use a vaporizer. They can obtain a prescription for Marinol, which is a pill, for Sesamet, which is a capsule, or for Sativex, which is a whole plant extract administered by a transmucosal spray. They can do any one of those things legally.
Can you just refresh my memory as to what conditions the three products you just mentioned are suitable for?
I think that they're in effect, they're replicants of Sativex is a whole plant extract, so anything that marijuana would be in a position to address, Sativex would be in a position to address as well. But I don't have, I'm sorry, Justice Cromwell, at the tip of my mind, each of the conditions that each of those substances would treat. The notices of compliance are in the record and would show that. I can say this, that the expert evidence didn't identify any particular condition, any specific condition that could not reasonably be treated by either dried marijuana or some other legally available means. The expert evidence didn't do that. The expert evidence was theoretical, and it was in effect, well, in theory, derivative marijuana products could offer these benefits. There had been no study of those things, and there were no specific conditions that were identified that were said, you can't treat these conditions with either dried marijuana or with these legally available derivative marijuana products.
Just while I have you stop there, Justice Chasson in dissent seemed to be of the view that a person could legally obtain the dried marijuana and then change its form legally. I was struggling with how one could do that and not be in possession of the other's substance.
Yes, I will say that question is raised squarely, I think, and I'll say this, that as from the government's perspective, the CDSA and the medical marijuana access regulations, the MMARs, regulate possession and access to marijuana, not use or ingestion. So neither the CDSA nor the MMARs purport to regulate use or ingestion. The CDSA makes it an offense to possess, to produce, or to traffic in these drugs. Doesn't say anything about use. And the regulations authorize access in the form of authorized possession or authorized production. Neither of those schemes say anything about use or administration. And if you actually look at the medical marijuana access regulations and the regulatory impact statements to some of them, they make this point, that the regulations don't purport to regulate that component. So if we look at tab...
I understand that they don't purport to regulate that.
Right.
What I was struggling with is how one could change the form from dried to some other prohibited form and not be in possession of the latter?
Right. I think it's because at a certain point, when you possess dried marijuana and you're in the process of using it, you have to use some common sense. If you applied the strictest definition of the offense of production, which means to alter the physical or chemical properties of a substance, if you take dried marijuana and you smoke it, then on the broadest, most absurd definition, someone would say, well, you're producing THC because you're changing dried marijuana into THC. But we don't approach it that way. We use some common sense, and we must use common sense. And so, for example, we must use common sense here the same way we would in distinguishing between trafficking and someone who purchases drugs. On the broadest definition of being a party to trafficking, a purchaser could be said to be aiding and abetting the trafficking by participating in the transaction.
Well, those are a lot of lawyer words, but is Justice Chiasson right or wrong?
He's right that the regulations do not purport to prescribe the manner in which people use or ingest the substance that they're authorized to possess. And so at the end of the day, you can acquire dried marijuana, and if you choose to ingest it orally or mix it into tea and use it, that's not proscribed by the regulations. They don't say anything about that. And so it comes a question of drawing lines. And in every case, in many, many fields, it's necessary for courts to draw lines. But one thing is clear. You can draw a distinction between, on the one hand, mass production of derivative marijuana products in a sort of assembly line situation, like we saw in Mr. Smith's case, producing large quantities of derivative marijuana products for distribution to others. That's one side. And the other side, on the other side of the equation, clearly very different. Choosing to smoke marijuana and thereby transforming its qualities or its chemical makeup by smoking it, or mixing it into tea and ingesting it. And so our point is, Justice Chiasson is right. The regulations don't regulate or prescribe that. All they do is authorize, they authorize possession, and they authorize possession of what is in effect the known substance that has been identified in some of the literature, at least, as having some medical properties. That's dried marijuana. And allow people to access it and then use it as they determine necessary.
I'm sorry to delay you, but I just want to be very clear. Justice Chiasson says, paragraph 153, this contention, which I won't get back to, is based on the proposition that it would be illegal for a person who is authorized to possess marijuana to transform the dry product into another form. Now, do you say that's correct?
Yes, not all. If you're engaged in use and you technically transform the dried marijuana into another form, even, for example, smoking it, that's common sense. That happens. No one's suggesting that that is production of a separate substance. That's using the substance you're authorized to possess. And we really have to use common sense when we apply that. Perhaps I could just take you to, if you look at the condensed book, and this is tab 7 of the condensed book, and to be clear, this is the marijuana for medical purposes regulations, which are the most recent regulations. The old regime that was in place in this instance has now been replaced by a new regime, the MMPR. But to be clear, the new regime maintains this restriction. It only authorizes access to marijuana and not derivative marijuana products. And if we go to the last page in tab 7, if you go to the second last page, the issue at the bottom is this is in the regulatory impact analysis statement, the RIAS statement that accompanies the regulations. The RIAS statement is not evidence, and it's not part of the regulations, but it shows the regulator's approach to particular issues. So in the RIAS statement, at the bottom of page 1756, they're dealing with the question of marijuana-infused products should be allowed under the MMPR. So they're considering that. And if you go over to the next page, the health response is listed. And then the reasons for that are given. And I'm going to come back to this. But if we just go to the last 2 sentences in that paragraph, it says this: there are no restrictions on how dried marijuana is to be ingested or inhaled, and patients may choose to use it, for example, in foods or by vaporizing. HC does not limit or recommend a particular method of administration. And that's entirely consistent with the regulatory model, which just says you're authorized to possess it. This is what you're authorized to possess it. You use it how you see fit.
But there's a little difference if you're actually changing it into another oral product and keeping that around so that you can put it in your brownies or whatever next week. What would you say about that situation? Would that not be offside?
I'm going to say that, as I alluded to a few minutes ago, there's a necessary exercise in line drawing in many, many areas of the law, and this may be one of them, where something goes from use or ingestion to actual production of a separate substance. And where that line is drawn is going to depend on the facts. Now, if you have a particular quantity of dried marijuana that you're authorized to possess, and you produce or you are using that and you mix it into something to ingest, that's one thing. But if you produce batches and you're carrying those around with you outside of your house, you're entering an area of risk. You're entering an area of risk where you're authorized to possess dried marijuana and then you're allowed to use it, or the law doesn't regulate how you use it. But you're not authorized to produce batches of separate substances. So at a certain point in that continuum, and it's going to involve line drawing, and as we know, in the abstract it's often very difficult to do, but when you have actual facts, it's not so difficult. This case is not a difficult one because it's mass production of large quantities of a derivative substance.
We have a criminal prohibition, and you're telling us that the line drawing is very difficult. That seems constitutionally problematic.
I don't agree with that assertion in the sense that I'm saying there may be some cases where the line drawing is very difficult. But what I'm saying is if you're authorized to possess a certain quantity of dried marijuana and you are engaged in using that and you, in the process of using it, put it into forms to allow you to ingest it, that's not the same thing as producing. And we know from common sense it wouldn't be producing to smoke it. It wouldn't be producing to mix it into something and eat it.
Can I keep you then on the line drawing common sense framework that you're urging on us? This is a case about line drawing and whether the line at dried marijuana is legal, constitutional, just on the level of common sense, looking at the evidence that was before the court. Can you explain in ordinary language why, since the scheme permits medical use of marijuana with the doctor's permission, the line was drawn at dried marijuana?
Yes, I can. And I think the best way to do this is to actually go back to the very document that I just referred you to. And I want to make the point that this is a regulatory impact analysis statement. It's not part of the law, but in answer to your question, Justice Bella, this expresses the point in a way that in a better way than I actually could. So if you look at it's tab 7, page 1757, the Department of Health response, the new regulations will limit producers to the production and distribution of dried marijuana only. The MMPR will not authorize extractions of active ingredients, i.e. resin, to be sold for therapeutic purposes. The only clinical studies on therapeutic use to date have been carried out used dried marijuana that was either smoked or vaporized. There are no clinical studies on the use of cannabis edibles, e.g. cookies, baked goods, or topical products for therapeutic use. As with other drugs, all products that claim to have health benefits must go through drug approval process outlined in the Food and Drugs regulations. And so that's really it. And so this is the way I would summarize that. I would say that if the government is forced to carve out a judicially mandated exception to the general principle under which the regulatory scheme operates, it's not irrational for the government to frame and limit that exception based on what scientific evidence is available. So, to be clear, the principle under which the FDRs and the FDA operates is that drugs should not be authorized for therapeutic use unless they're shown by scientific data to be safe and effective. Now, there has been, in effect, a judicially mandated exception to that for marijuana based on the Parker decision and the government's response to it. But my point is this: if the government is forced to create an exception to that general principle, it's not arbitrary for the government to frame that exception on the basis of what information there is out there, and that does exist. And so what Health Canada is saying is, leave aside anecdotal opinions of individual witnesses The science, what science there is on marijuana, has been done with respect to dried marijuana. That's the known quantity. We don't know the implications and effects and utility of derivative products, which are in effect, many of them, much more concentrated, like THC and cannabis resin. We don't know those things, so we're not going to regulate them, because to do that would be to go against the general principle of the regulations. So let me explain it this way. The regulatory approval process for drugs in Canada. Access to drugs in Canada is strictly controlled. There are two statutory pillars for Canada's drug regime, the CDSA and the FDA. These statutes operate together to prohibit access to drugs with a history of abuse, that's the CDSA, and to regulate access to all drugs for therapeutic purposes, that's the FDA. So it's prohibiting drugs that are liable to abuse, CDSA, regulating access to drugs for therapeutic purposes, the FDA. Now, under the legislative scheme, there are three means of obtaining access to a new drug for therapeutic purposes. One, the new drug approval process. And as I already pointed out, there are three cannabis-based pharmaceuticals that have actually gone through that process. So it's not as though it's impossible. Two, clinical trials. So in the course of seeking a new drug approval, you can seek approval to conduct a clinical trial of a substance that's not yet been approved for use. Third, the special access program. And this is a case-by-case authorization to use a presently unapproved drug based on demonstrated need by a physician in a particular case. So a very, very flexible, okay, this drug is cutting edge and controversial, not yet approved, but here I have a patient who can't be treated by other means, I want special access. That's a very nimble element of the scheme. Now I'll say this, that on the approach the courts have taken, there appears to be a fourth means of obtaining access to a new drug in Canada. The fourth means is what I would call an extra regulatory means. You produce the drug, you distribute it, and if you're prosecuted, you call evidence in court to prove on an anecdotal basis that someone believes they need the drug and that it helps them. That's the fourth extra regulatory model. Now, there are court cases where this has happened, most notably Parker. But the concern that I've identified highlights the need for deference when courts are being asked to pronounce on the manner in which Health Canada classifies, regulates, and approves drugs for therapeutic purposes. If it's not carefully circumscribed, this fourth route has the potential to overwhelm or overtake the entire premise of the regulatory model, which is that drugs should not be made available for therapeutic purposes unless shown by scientific study to be safe and effective. Now, this point that I've just made goes directly to the burden of proof at the section stage of the Section 7 analysis. How so? Because, as I said earlier, in effect, the courts below said, well, arbitrariness, the government hasn't shown why there are specific health risks associated with derivative marijuana products that are not present with regard to dried marijuana. And the problem with that approach is that it flips the burden under the second stage of the Section 7 analysis on its head by saying the government has to prove that the law is not arbitrary, when the rule is that the onus is on the applicant, the proponent, to show that the law is inconsistent with the principles of fundamental justice, that it is arbitrary. And I'll go one step further. The court below, the trial judge, accepted that it might be rational or might be reasonable or logical. I think the word was logical. It might be logical to assume that certain concerns were present, but, quote, I would have expected to see better evidence of that. And that's the point, is that here the courts are applying expectations that certain risks be proven by evidence in court when the entire basis for the regulatory model is, unless things are shown by scientific evidence to be safe and effective, we're not going to allow them to be approved.
The difficulty that I'm having with this is that it's a criminal model. And you keep talking about it being a regulatory model, and everything you say may apply to that. But we're talking about criminal law here and exceptions to criminal law. And certainly it is a way of regulating, but it's regulating with the heaviest instrument the law can apply. And when you do that, you come into Section 7 territory. That is a concern I have.
Right.
Perhaps you can allay it.
Yes. I'll say this, that the kind of concern that Chief Justice said you've just articulated is not one of irrationality or arbitrariness. So you're not saying, well, that's not a rational way of doing it. You're saying it's the heaviest hand. That's a question of, is it grossly disproportionate or overbroad? That becomes the question. And here,
Well, what becomes the question is that you're putting people in risk of imprisonment as opposed to the usual regulatory scheme where there would be.
right. Well, I'll just say this, that consider the conduct of the person who's charged in this case, okay? Mass producing large quantities of derivative products for distribution by a dispensary that was operating completely outside the regulatory scheme, okay? Even under the regulations as they exist, medical marijuana authorization access regulations, you're not authorized to run a dispensary. The regulations authorize possession and production for medical purposes. They don't authorize dispensation by third parties. Take it beyond that, this organization had some 3,700 to 4,000 members, only 5 to 10% of whom had medical marijuana authorizations to begin with. And the same organization, the evidence from the principal of this organization, I think is R.v.Smith, he testified that of those members, he had to take away 500 to 600 memberships from people that he suspected were reselling marijuana. All of that to show that it's necessary to maintain strict controls over marijuana and access to marijuana because it's a drug of abuse. And that question, Chief Justice, that was resolved in Malma-Levine. We don't need to have that debate again. We don't need to say, is it appropriate to have marijuana as a controlled substance? That was resolved in Malma-Levine. It's not even an issue here. And indeed, Canada has international commitments to regulate that.
My point was a very narrow one. It may be slightly different than an ordinary regulatory scheme.
Yes.
Because of, as you say, the legitimate, to some extent, potential for imprisonment, but it is a different sort of situation. And so when you're bringing in all these regulatory principles and saying, well, you know, you've got to give a lot of leeway to the government, et cetera, it may take on a different complexion when the result of running afoul of one of those regulations is a criminal record, incarceration, and so on.
Really, Chief Justice, in my respectful submission, what you're alluding to there are questions of gross disproportionality and overbreadth. Is this the right tool? And even those are highly circumscribed. I think in Carter, the court appeared to allow for a considerable degree of deference in respect of complex regulatory responses. And I'm going to suggest no one would say that the regulation of drugs along the spectrum, from preventing abuse of drugs that are liable to abuse, psychoactive drugs, et cetera, all the way to allowing access to drugs for therapeutic purposes, no one would suggest that's not a complex field that requires many different parts. And so what the court said in Carter was, in contradistinction to the scheme there, saying the scheme and issue there, which had to do with prohibitions against assisted suicide, it was not a complex regulatory field. And so less deference was owed. And here, it is a complex regulatory field, and deference is owed. Now, I need to move on then to address the specific issues. The question of standing. This court has consistently held that no one can be convicted under a law that's unconstitutional. Now, I say it's questionable whether this point applies to the respondent in this case, and let me explain why. He was charged with possession of THC for the purpose of trafficking under the CDSA. In response to that charge, he argued that the medical marijuana access regulations were unconstitutional. Now, the underlying conduct, he chose to supply marijuana products to an organization that was operating completely outside the MMAR scheme. And let me explain what I mean by that. The MMAR scheme authorizes possession and production of marijuana for medicinal purposes. It never has authorized distribution. It doesn't do that. And so this was an organization that was operating completely outside that model. And so the scheme does not allow for and has never allowed for the operation of marijuana dispensaries. So it's hard to see how the constitutionality of a scheme that authorizes the possession and production of marijuana for medical purposes could be relevant to someone charged with possession of THC for the purpose of trafficking, and in response to the charge, he alleges a deficiency in a regulatory scheme that could never authorize his conduct. That's the point. Is there a point at which someone who operates entirely outside a particular regulatory scheme has the ability to raise alleged deficiencies in that scheme as a defense to a criminal charge, even though that scheme could never apply to them? It's not the same thing as Morgenthaler, where the person is charged under a criminal section and the defense is in that section. It's being charged with an offense under this provision, under a statute, and pointing to a regulatory scheme that, operating in a different context, could, in theory, authorize some conduct by other people, but not even in respect of the very offense that you've been charged with, trafficking.
Is this really a question of standing, or is it more related to remedy? Because another way of putting what you're saying is that if the court cures the unconstitutionality by reading something into the statute or reading something out of it, and that has no impact on the particular accused, then the law remains in force.
No, because what happens in the situation you've just described, Justice Cromwell, is someone who could never have benefited from the alleged constitutional infirmity in law, not to say, well, the offense is unlawful, invalid. The offense was still present, is somehow bringing an application, getting relief, and that relief can never apply to them, and it leaves in the air this finding of unconstitutionality that doesn't, in effect, change anything in that case. And so the bottom line is that, sure, no one can be convicted under a law that's unconstitutional, but here it's a regulatory scheme that might provide an escape to a conviction, but that regulatory scheme couldn't have applied to this applicant in these circumstances. And that's the refinement that we're saying should be considered. Now, I should also address, some of the interveners have referred to public interest standing. And on that question, public interest standing, I would say this: if the person is caught in a criminal case and doesn't have standing as a result of the Big Ab drug mart principle, is it appropriate to allow them to say, well, even though I don't really have standing in response to the charge I'm facing, I should be allowed to raise this matter as a question of public interest, when we know from cases like Downtown Eastside sex workers, Carter, Bedford, we know from those cases there are situations where if someone feels that a law is unconstitutional and wants to raise it in a forum that doesn't involve breaking the law, they can do it. So if it's not appropriate for a person they don't have standing in respect of a criminal charge, they shouldn't in the same case have access to the public interest standing principles. That brings me then to the charter analysis and the two stages of the charter analysis. The first one is the life, liberty, or security of the person analysis. At the outset, I'll acknowledge that because Mr. Smith was charged with a criminal offense, his liberty interests were engaged. However, the key question for the courts below is, what is the scope of the liberty and security of the person interests at stake? Because the jurisprudence makes it clear that the scope of the liberty and security of the person interests that are at stake will involve or will dictate the nature of the principles of fundamental justice analysis, the second stage. So if it's just a liberty interest that's engaged by the fact of a criminal charge, then the general answer would be, okay, well, if you're at risk of going to jail, then the principles of fundamental justice demand that you have a fair criminal trial based on proof beyond a reasonable doubt and all the principles of fairness that are entailed in that. The question here is, are there additional liberty and security of the person interests beyond mere imprisonment that require a fuller consideration of, well, is this law arbitrary, disproportionate? Is it some way failing in one of those principles? And so that's the same kind of analysis that you'll see in Malmo-Levine, where the court looked at the question of imprisonment and then went beyond that and said, are there broader interests at stake that require consideration? The answer in that case was no, there weren't, because lifestyle choices didn't get caught by Section 7 of the Charter. The same analysis took place in Parker. The court accepted that liberty is engaged because of the potential for imprisonment, but went on to say, but are there medical issues at stake here? And that's the question here. And our position is this, that when you look at liberty and security of the person interests and whether those are engaged in the context of claims to access to a substance that's otherwise illegal, it has to be an objective standard or threshold and it has to be one that involves a consideration of, well, are there other reasonable legal alternatives available other than the one that you're seeking? So if you're claiming access to a medical treatment, and there are other available treatments that are actually lawful, it's not a breach of the principles of fundamental justice to say, well, you might prefer this illegal treatment over the legal one, but that doesn't intrude upon your liberty. There are ways for you to treat the condition that you're suffering from.
You accept, I think, that the liberty interests of the users is implicated? Because what they are doing would be criminal.
On the same basis, Justice Cromwell, yes, that they could be prosecuted, yes.
And if that's the only Section 7 interest implicated, is your case better or worse?
It's much clearer, because you'd say, well, someone is facing prosecution and could go to jail for committing an offense, the offense being unauthorized possession or production of a controlled substance. And the question is, if there are no medical issues associated with that, no additional liberty or security of the person concerns, the question is it consistent with the principles of fundamental justice to allow that person to be convicted of that offense? And the answer would be, if the Crown proves the offense beyond a reasonable doubt and the accused has a fair trial, then the principles of fundamental justice are addressed. It's only...
But I thought that what's being challenged is the criminalization of the possession of the particular substance, and the legal issue is whether that's arbitrary. Having difficulty seeing what difference it makes, what other Section 7 interests are implicated.
It's not a challenge to the criminal offense of possession of those substances. It's a challenge to the under-inclusiveness of a regulatory scheme that allows for medical access.
The result of which is to make the offense unconstitutional.
Right, but the claim is, I need a substance to treat a medical condition that I can't otherwise treat. Or that should be the scope of what is protected by Section 7. It shouldn't be, I prefer this illegal treatment over that one. If that's all it is, then what you have is based on health concerns. So there's a recent case about access to raw milk. You know, I believe that pasteurized milk is not healthy and it causes health problems. So I want to have access to a raw milk collective. And the law that prohibits me from doing that is inconsistent with my Section 7 rights. And the Ontario Court of Appeals said, well, no, just because you personally believe that pasteurized milk has health concerns, there's no objective basis to your claim that that infringes upon your liberty, because there's no objective support for that.
I don't want to delay you, because I know you have a lot of ground to cover in a short amount of time, but I just want to signal to you that I'm not following this line of reasoning at all.
Right. Well, I guess I'd say this. If we look at the condensed book, and in particular the Malmo-Levine decision, which is at tab 8, if you go to tab 8, paragraph 84, we say at once the availability of imprisonment for the offense of simple possession is sufficient to trigger Section 7 scrutiny. However, Malmo-Levine's position requires us to address whether broader considerations of personal autonomy short of imprisonment are also sufficient to invoke Section 7 protection. So are there a broader range of interests that have to be considered at the second stage of the analysis? Are there, and so in this case, in Malmo, it was lifestyle choices. In the case at Barr, it's health concerns. That more specific issue was dealt with in the Parker case. That's at tab 10. And if you look at Parker at paragraph 81, in one sense, this is paragraph 81, second sentence. In one sense, it would have been sufficient to identify the clearest of those infringements, the possibility of imprisonment. This interference with Parker's liberty interest would conceivably be sufficient to require determination of whether the deprivation accords with the principles of fundamental justice. However, in my view, this would not adequately capture the defects in the legislation and would fail to come to grips with the context in which the issue arises. And then there's a reference to another case where it says the contextual approach attempts to bring into sharp relief the aspects of the right to freedom which are truly at stake, as well as the relevant aspects of any values. The importance of the right or freedom must be assessed in context. And so the court then goes on in paragraphs 82 and following to say, in 83 and following, to say the question is, are there liberty and security of the person interests associated with health that are above and beyond imprisonment that are an issue here? And it would only be if those health concerns are ones that are caught by liberty or security of the person that you would say, well, you need to scrutinize the law and the principles of fundamental justice against those deprivations.
Just glancing, I didn't think it was only. I thought the contextual argument was that you amplify it.
That's right.
But it's the way your argument was sounding to me was we forget about the imprisonment part.
No.
We've just focused on whether standing alone this would be a deprivation of liberty and therefore alternatives are an answer. But the problem some of us may be having is that it's not just a simple question of whether that's the deprivation of liberty. That's part of it, but there is a fundamental deprivation of liberty which resides in the threat of imprisonment. You can't wash that out because of these other aspects.
But my point is this. If there's no health component or infringement upon autonomy to obtain treatment for a medical condition that's part of the liberty interests that are engaged in a particular context, then you don't consider those things when you're saying, is the deprivation consistent with the principles of fundamental justice? You don't ask yourself, does this law deprive people of access to health care in a way that's arbitrary? Because there's no health care concern. It's only the potential for imprisonment. So it affects the subsequent analysis. And the arbitrariness test would be completely different. It's a question of, does a law that prohibits access to a substance
but there seems to be, I think you have to look at them both, don't you? I mean, it's a health care issue. You have one side of that, the other people have the other. But there's health care as part of the picture and deprivation, and mixed in is the fact that it's a criminal regime used to enforce this, and you are facing imprisonment as a result of how this health care scheme is has been set up. And so that's what I thought they were saying in Parker. You have to look at the whole ball of wax and how it interacts. And you seem to be saying you look at one or you look at the other.
Well,
perhaps I'm misunderstanding you. I'm sorry.
Yes. Well, Chief Justice, you're saying, well, there's no question it's a health care issue. My point is that it's only a health care issue that engages liberty or security of the person if you show at the first stage of the analysis that what you're talking about are limits on health care that actually engage liberty or security of the person. So it's not enough to say, well, it's health care. We claim health care. Let's then ask, does the deprivation of my access to health care intrude upon the principles of fundamental justice? It's only if the health care limitations rise to the level of restrictions on liberty. And so in Parker, the court made a thorough analysis of the infringement on Mr. Parker's access to health care and said, well, in that case, it actually is met because the law prohibits him from treating a very serious and life-threatening medical condition with the only substance that he's shown is effective in treating that condition, marijuana. And all the other alternatives had been considered and ruled out. So synthetic drugs had been ruled out, other treatments. The court considered and carefully scrutinized that. I say if you apply that template to these facts, you don't get any further than saying these applicants expressed a subjective preference for derivative marijuana products for some of their conditions, some of the time. And they didn't.
What do you say about the evidence that the findings of fact to the trial judge on that?
Right. I say two things. One, if you take the evidence at its highest, the question becomes, does it meet the legal threshold? And without debating the evidence, I say if you actually look at the evidence, not debating it or weighing it, looking at it.
Can we just, at this level, focus on the findings of fact? Because we don't really get into the evidence. The findings of fact of the trial judge, could you address those?
Right. Well, I think the judge held, the problem here is the judge held this is access to medically necessary treatment. But the question becomes, what evidence, what were the findings that supported that question? And at the end of the day, what it was, three things. One, the subjective views of the witnesses that said, well, we use derivative marijuana products some of the time for some of our conditions. And then expert evidence that was not medical evidence saying this person can't treat their condition, this specific condition, with any other means.
Well, we have rules for when we can override a finding of fact.
Right.
Or mixed fact and law, and they're in a case called Housen, and there's lots of other cases. And,
Yes.
And we just can't go beyond, as you're inviting us to do. It's not permissible. So you've got to tell us that the finding of fact, show us why the finding of fact was totally unfounded on the evidence, not that you disagree with it. We know you disagree with it.
Right. The best I can do at this point, given my limited time, is I can say I've addressed that question in the factum by saying that the legal effect of an undisputed set of facts is a question of law, and that there's lots of support for that. JMH is one case where the court said that. The legal effect of undisputed facts. Taken at its highest, the evidence in this case was not legally possible, legally capable of meeting the threshold that's articulated in Parker. The second point, and I've made it in the factum, I won't be able to go through it in detail, is that there were extricable errors on the part of the Court of Appeal in its assessment of whether the evidence supported the conclusion. And those extricable errors had to do with relying on subjective expressions of preference by lay witnesses, suggesting, well, that may be enough in some circumstances, and in effect, Justice Garson said that. Relying upon expert evidence that did not go to the specific question. It was general. The expert evidence was, in theory, because I haven't done any studies, but in theory, these derivative marijuana products could, in theory, be better treatments for certain things.
That included your own witness. Mr. Abramovich from the Department of Health confirmed everything that Dr. Pate said.
I think what he said was, in theory, some of these things are true, but sometimes when we apply them in practice, we don't know until we actually do the studies.
But he had never applied them in practice because his role was simply collating all the research.
Right. Our point is,
there was no dispute in the evidence, was there?
Our point is no one's applied them in practice because they haven't been studied. And the third aspect that the trial judge relied upon was the fact that some of the witnesses, after the events in question in this case, after the charges against Smith were laid, obtained medical marijuana authorizations under the scheme. And that's legally irrelevant for two reasons. One, it doesn't relate to the time frame in which the substances were being produced. And two, those are for access to dried marijuana. They authorize those individuals to have access to dried marijuana. They don't say you're authorized to have derivative marijuana products. And then the Court of Appeal referenced, well, some of those forms reference routes of administration. Justice Chasen's point about that. The regulations don't restrict the manner in which you choose to use the substance. So I have very limited time, and I have to move on to the question of the principles of fundamental justice. If the second stage of I say this to summarize, if you apply Parker and what the Ontario Court of Appeal subsequently said about Parker in a case called Myrna, if you apply those thresholds to this evidence, because in Myrna the court said, look, you need to have more than just a subjective preference for marijuana in order to establish that your rights have been infringed, that your right to liberty and security of the person has been infringed. You need to present evidence to show that that is a reasonably necessary means for you to treat a condition that you can't otherwise treat. That's what the court said in Myrna. If you apply that threshold to this evidence, it can't meet that threshold. The evidence never addressed those questions. And so if you go to the second stage of the analysis, our argument is that fundamentally that the Court of Appeal and the trial court, when we look at the principles of fundamental justice, they reverse the burden by saying, and I won't have time to take you through the passages, but the court said at a number of stages, well, this may be logical, but we didn't see any proof. The Crown didn't prove that regulating these substances is more difficult than regulating dried marijuana. The Crown didn't prove that there are additional risks, health and safety risks associated with these derivatives that aren't present with respect to marijuana. And my point about that is that the Crown doesn't have to prove it. Under the arbitrariness analysis, the burden is on the proponent to show that the deprivation of interests is inconsistent with the principles of fundamental justice. Here, the court seemed to accept that there was some logic to the government's regulatory model, but said we didn't prove it. And the problem with that, where the rubber hits the road, is that the very nature of the model is it operates on the premise that unless you can show that something is safe and therapeutically effective, it shouldn't be authorized under the scheme, because we're not going to be in the business of authorizing therapeutic uses of substances that haven't been properly studied for reasons that relate to cases like thalidomide and other drugs that people assumed were okay, but they ended up not being. Without the science, they don't know. So that's the fundamental point with respect to the principles of fundamental justice. There's another area in which the court erred. The court said there might be other ways, other than criminalization, that would address some of these concerns about misusing drugs. And my point is, on that is the same as the one I made at the outset in response to a question from the Chief Justice. That's not a question of arbitrariness. That's gross disproportionality or overbreadth. The court said this law fails on arbitrariness. And there, the question is only the rationality of the means, not whether there are other approaches that might be more effective. When we look at gross disproportionality and overbreadth, you'll see that this scheme is actually very flexible. It's not, as it was in Parker, a blanket prohibition. It allows for medical access to the one substance which is a known quantity, at least to some extent, which is dried marijuana or marijuana. It doesn't allow access to substances that are, as yet, there's no medical study to show that they have any medicinal benefit that can't be obtained by the one that's available. So it's flexible in that respect. It also has, as I mentioned before, other means to obtain approval for drugs that are not presently authorized, including a special access program. And the special access program allows an individual who can't get access to a drug through legal means to apply with the support of a physician to say, I need to get access to this drug. There's no other way to treat my condition that's legally viable, so I need access to this experimental drug to do so. And that provides flexibility that shows that this scheme, which has a general rule and has built-in flexibility, it's much different than a simple blanket prohibition. It's a more flexible scheme. Now, I need to address, in the last 3 minutes that I have, the question of remedy. And I will say this, that the Crown says we should succeed on the merits for the reasons I've given and the reasons mentioned in the factum. But if the Crown doesn't succeed on the merits and there's an adverse ruling, the Crown will need time to respond. This is the first time that this court will have pronounced on the validity of the medical marijuana access regime. It's the first time that there will be a ruling of national application on this question in an appellate court. It's a complex area, a complex regulatory environment. There are many stakeholders to be consulted. A suspension is justified on both public safety grounds and on the basis of the rule of law. With respect to public safety, there's significant public safety interest in the continued enforceability of the CDSA prohibition against possession, production, trafficking. If a finding of unconstitutionality is upheld, it could be construed as leaving a gap in the legislative scheme. This could jeopardize the ability to prosecute offenses under the CDSA, including trafficking and production. With regard to the risk of diversion, I don't need to go any further than this case, in which one of the witnesses, R.v.Smith, testified that his club had revoked 500 to 600 so-called memberships that it had offered to individuals who were suspected of reselling drugs. So in terms of the risk of diversion, it's present on the ground here, and that's just one piece of evidence. With regard to the rule of law, if a ruling that the MMARs are invalid is upheld, this could be perceived as leaving a gap or lacuna in the law that would cause considerable confusion. It's a complex regulatory environment evidenced by the host of interrelated statutes and regulations that are listed in the Crown's factum. Addressing the rule of law, the court may consider whether or the extent to which there has been what's referred to as a dialogue between the courts and the legislative branches of government. If we look at the history of the MMARs, you'll see that the government has responded to various court rulings robustly, with substantive changes and refinements each time the scheme has been challenged. The government has to balance its concerns over the control of substances identified nationally and internationally as substances of abuse with the obligation to comply with court rulings. The government would need time to develop an appropriate regulatory response and take steps to implement it. If you look at the re-ask statements, the impact statements for each of the iterations of the regulations, and there have been many, there's common ground with my friends that this is an area that has been exceptionally litigious. If you look at the re-ask statements, you'll see each time the government has made a regulatory response, it has had to consult with stakeholders, many of them, consider the implications of its programs, and address refinements to the scheme, trying to balance all of the interests that it has to deal with. If you look at the magnitude or the complexity of the problem, how many people it affects, it's not insignificant. So the re-ask statement for the MMPRs, the new regulatory model, which carries on with this restriction to dried marijuana and doesn't allow for derivatives, it says this: in 2002, there were 477 individuals with authorizations to possess marijuana under the scheme. In 2013, there were 29,000 individuals with authorizations, and it was estimated that by 2014, there would be 50,000. It's already a massive and complex program, and expanding it to include all substances listed in Schedule 2 of the CDSA, which is what the judge did, didn't just say delete dried marijuana. He said in a subsequent oral ruling, the way to fix this is to read into the MMARs the reference to all marijuana means every substance listed in Schedule 2. Expanding that would be a very, very significant change, and it would require time to consider.
Yeah.
Just ask you one narrow question. You're not seeking an order for a retrial?
To be clear, if the Crown's appeal is allowed, we are seeking an order for a retrial, and let me explain why that is. The judge in a pretrial ruling held that the MMARs were constitutionally deficient. We say the judge shouldn't have done that for the reasons, didn't have standing, and on its merits it was wrong. But at the end of the day, because of that ruling, the Crown was not in a position to prosecute its case. And let me explain why that is. The defense had indicated at the outset of this case, we're going before a jury, and we're going to argue the common law defense of necessity. Now, if that had been presented to the jury as a defense, the Crown would have said, well, that defense fails because there is a reasonable legal alternative to the conduct that you were involved in, namely the medical marijuana access regulations provide a means for medical access. And in response to that argument, I think it would be absolutely certain that Mr. Smith would say, yes, but the judge has already struck down that provision, already found that that provision or that scheme is constitutionally deficient. So could we have been expected to comply with that? Was there really a reasonable legal alternative? And faced with that, in trying to instruct a jury on that question, on the basis of a law that had been, in effect, ruled unconstitutional by the law, it was completely unworkable. And so the Crown made a decision, this ruling has significantly impacted on our ability to prosecute this case. We can't prosecute the case in light of this ruling. If the ruling is overturned, the Crown wants to prosecute the case.
Well, you don't say that. You just ask that the appeal be allowed.
Right. Well, I mean, it's an appeal from an acquittal.
Okay.
Yes.
Anyway, I think we've taken enough time on this.
Right.
Thank you.